Well, first off, good morning, good afternoon, or good evening, depending on your time zone. I can see from the participant list that we are joined by people from across the world, which is great. Thank you for joining us. My name is Russell Buchan, and I'm a senior lecturer in law at the University of Sheffield in the UK, along with Emily Crawford, who is an associate professor of law at the University of Sydney in Australia, and Ryan Lidwer, who is an associate professor of law at the University of Queensland, also in Australia. We are the editors-in-chief of the Journal of International Humanitarian Legal Studies. So this is an academic journal that publishes peer-reviewed articles, review essays, and book reviews on the application of international law to humanitarian crises. And it covers a wide range of international legal regimes, including international humanitarian law, international human rights law, disaster law, refugee law, the law of peacekeeping, etc. So having recently, or fairly recently, assumed editorship of the journal, Emily, Ryan, and myself have sought to draw attention to the journal through different events and engagements. We agreed that an annual lecture would be useful and an important event in the calendar of the journal, and today marks the journal's inaugural annual lecture. The annual lecture will be published in the following issue of the journal, which we publish towards the end of this year. So please do keep a lookout for that. And I should say that all publications appear online as advanced access as soon as they are ready. So do keep an eye on the journal's website. Now, when we decided to hold an annual lecture, Ryan, Emily, and myself immediately agreed that Professor Michael Schmitt should be invited to deliver it. In addition to his achievements in the field of international law, to which I'll return to in a moment, Professor Schmitt is also a long-standing member of the journal's advisory board. And since we took over as editors-in-chief of the journal, Professor Schmitt has been a constant source of advice and support, and also a trusted friend. So let me say a few words by way of introduction to Professor Schmitt. Prior to joining academia, he served in the US military, and in particular, the US Air Force as judge advocate. I once made the mistake of saying that Mike was in the army, which I won't make again. Since joining academia, Professor Schmitt has held multiple distinguished positions. Currently, he is Professor of International Law at the University of Reading, the G. Norman Lieber Distinguished Scholar at the US Military Academy, West Point, Charles H. Stockton Distinguished Scholar in Residence at the US Naval War College, Strauss Center Distinguished Scholar and Visiting Professor of Law at the University of Texas, and a Senior Fellow at NATO's Cooperative Cyber Defense Center of Excellence in Tallinn, Estonia. Mike has also published extensively in the field of international law, and I'm sure you'll be familiar with these publications. You'll also know that Mike is the general editor of the Tallinn Manual projects. The first edition of the Tallinn Manual was published in 2013 and assessed the application of international law to the phenomenon of cyber war. Tallinn Manual 2.0 was published in 2017 and examined how international law applies to cyber operations more generally. And I carry it with me everywhere I go, so this is Tallinn Manual 2.0. And we now know that the Tallinn Manual will be entering its third edition, and perhaps Mike will say a few words about its scope, focus, etc. during his lecture. We have 1 hour for today's lecture, and I understand Mike will talk for approximately 40 minutes. This means there will be time for questions and answers at the end. And to ask questions, please submit them via the Q&A chat function at the bottom of the screen after the lecture, and I will collect them and pose them to Mike. The title of Professor Schmitt's lecture is, as you can see, International Humanitarian Law in Cyberspace, Quo Vadis. Mike, who I believe is joining us from the Lone Star State of Texas, huge thanks for agreeing to deliver this lecture for the journal. We are very much looking forward to it, and the floor is yours.
Thanks, Russell. Thanks. It's a real honor to be asked to give this lecture, not only because I admire the journal, but I happen to admire all three of the editors-in-chief. So thank you very much. What I thought I would talk about is the future. Where are we going, Quo Vadis, where are we going with respect to international humanitarian law has applied in cyberspace? And so I'm going to look out, no particular distance, but just ask what's the vector, what's the direction of international humanitarian law has applied to cyberspace now that we're finally finished with that tiresome question of whether IHL does apply to cyber operations. Of course, pretty much everyone agrees that it does. Now, whenever I look out into the future about international law, there are certain operating premises. The first one with respect to international humanitarian law is you must understand that humanitarian law and armed conflict, combat, war, they're in a synergistic relationship. It is true that international humanitarian law will shape conflict. I mean, after all, we're talking about the rules of the game. So whether it's a new rule of the game or an old rule that is being interpreted, it will shape conflict. But I think what's often missed is that conflict really determines the direction of IHL. Before we interpret IHL, we have to understand the environment that IHL will apply to. And that's typically a reactive dynamic. So, for example, in 1905, there's a war between Russia and Japan, and what eventuates in part is the 1907 Hague Conventions. In World War II, we have a global conflagration, and what results the 1949 Geneva Conventions. So typically, humanitarian law reacts to something that has happened in the battle space. That's not always the case. We currently have autonomous weapons discussions. We do have some automated weapons that law is reacting to, but this is an example of a proactive IHL development that will shape warfare. But usually it's reactive, so we can expect IHL to react to the advent of cyber. Now, with respect to cyber, that process is already underway. We have, for example, military manuals that are dealing extensively with cyber. The Department of Defense manual is a good example, but there are many others, the German manual, the Danish manual. For those who are affiliated with governments, you know that there are lots of rules of engagement with respect to cyber-enabled operations. They are highly classified, but nevertheless they exist. There are non-state efforts. The ICRC is very active in this space, has been doing great work. The Tallinn Manual 3.0, we will readdress IHL in cyberspace. But the one problem we're having in this field is that from the very beginning, the capabilities in cyberspace that states and non-state actors are wielding are far outpacing legal consideration. One of the reasons we did the first Tallinn Manual was because states were developing cyber capabilities and cyber doctrine, and the lawyers had never even thought about the issue of, well, how in the world does IHL govern this new form of warfare? Another operating premise, whether it's with IHL or any other form of international law that I usually apply, is that if law is going to be effective, it must necessarily evolve. It must be responsive to the context in which it applies, or states will simply not abide by it. And so the process of evolution occurs in one of three ways. Either you have new norms emerge. I'm not optimistic that we'll see a lot of new norms emerge with respect to IHL in cyberspace. Old norms will pass into desuetude. Again, I don't think that's going to happen with regard to IHL in cyberspace. Where all the action will be in the interpretation of the extant norms, the norms we already have, the rules we already have. How does customary law apply in cyberspace? How do the additional protocols apply in cyberspace? Most of the work that we will have to do in the future will be about taking a rule like do not direct attacks against civilians or civilian objects and interpreting that in the new context of cyber-enabled conflict. Now, this process will involve lots of players, NGOs, Human Rights Watch, IGOs, tribunals, international tribunals, the ICRC expert groups like the Harvard Manual or the Tallinn Manual group, individual academics like Emily and Russell and Ryan and others who are online. But at the end of the day, I still believe that states and states alone make international law and they authoritatively interpret international law. What we are doing as non-state actors is influencing the process by which states sometimes powerfully influencing the process by which states either make law or, more accurately in terms of IHL, interpret international law. Now, if law is responsive to context, we have to ask, what about the context? Well, first, I'm sure most folks know cyber is present in conflict, armed conflict today. These are extracts from a speech by Mike Burgess, who is the director of the Australian Signals Directorate, the Australian equivalent of GCHQ in the UK or United States Cyber Command in the United States. And he was describing an operation in which folks operating from Australia, cyber operators from Australia, were conducting operations to degrade communications of Daesh halfway around the world in the Middle East. And because the Daesh fighters could not communicate with each other, they were in disarray, which allowed the kinetic forces to close in and to successfully engage them. So we have an operation that was enabled by cyber capabilities halfway around the world, as he says, as Mike says, 11,000 kilometers from where the engagement occurred. And this is not unusual in modern warfare. The United States has openly admitted that it does the same thing, as has the UK. Israel has reportedly used cyber against Hamas. Russia has famously, repeatedly used cyber against Ukraine in its international armed conflict with Ukraine. Non-state actors are very active in this space. There's Syrian Electronic Army, ISIS, and so forth. I think it's fair to say that today, every armed conflict in some way involves cyber-enabled operations. Those operations may be very complex, like the Australian operations, or the operations may be as simple as using a mobile phone to gather and transmit intelligence, to use social media to recruit fighters. We must remember, though, that as cyber finds its way into war, our societies are increasingly reliant upon cyber. I think cyber is really still in its infancy. I mean, the very fact that this lecture went on in the midst of a pandemic is an indication of the extent to which societies rely on cyber capabilities. Imagine handling the pandemic without cyber capabilities. When I took my vaccine shot, I signed up online. When I tried to get my mom a vaccine shot down here in Texas, I spent hours online trying to find that vaccine. We all looked to communications that were online for guidance on what we should and should not do. That is how the state communicated with us with regard to the precautions we should take. That's how we continued to teach students in our universities. So I think at the same time that we acknowledge that cyber is becoming central in warfare, we have to understand that cyber is of growing influence in our daily lives. And that will have a lot to do with the direction IHL will take in cyberspace. Now, I mentioned examples of using cyber on the battlefield, in the battle space. That will grow and grow and grow. In the future, most methods and means of warfare are going to rely upon cyber. I come from an air environment. Everyone's constantly talking about swarming drones. Swarming drones will rely 100% on cyber capabilities. We think about maneuver. When we're thinking about warfare, when I teach at the War College, we talk a lot about maneuver in the battle space. Today, foot soldiers in Afghanistan or elsewhere in the world, Mali, use cyber to figure out where they are. If you're on a mountaintop in Afghanistan, you use cyber capability connected to the GPS to figure out where you are. And the aircraft flying above you will rely upon ground and navigational systems. Space-based systems know where it is. Logistics, we ran an exercise at the Naval War College, a very interesting exercise, where the premise was that we were going to fight a naval conflict, fight a naval battle in the Pacific. But in order to do that, we had to move forces from the East Coast across the United States to the West Coast to embark on warships sailing from West Coast ports. And the exercise was all about hostile cyber operations against logistics that made possible moving those forces, moving that material to the West Coast. And what we found was that the cyber operations could completely shut down that particular operation, making the operation from West Coast ports basically impossible. Communications, even today, when a soldier is on a mountaintop in Afghanistan, the few remaining soldiers, he or she can open a computer on a mountaintop in Afghanistan and engage in a chat room with colleagues, both back at headquarters and elsewhere on the field. Intelligence, surveillance, reconnaissance, whether you're using a mobile phone to transmit what you're seeing, to using a satellite to transmit data, relies upon cyber. And all of these cybers, what you must remember is all these cyber capabilities, they are creating opportunities. But at the same time, every cyber capability also creates a vulnerability for your forces. So this is in part the context in which we are operating. Now, to understand how IHL is going to evolve, we have to understand the nature of these cyber-enabled operations. First and foremost, they're really, really, really fast. And that's in part why cyber is used by military forces. They use it because they want to get inside, they want to leverage it, get inside the enemy's OODA loop, observe, orient, direct, act. In other words, militaries today are training to use cyber capabilities in communications, intelligence, for attack operations. They're trying to move more quickly than their enemy. What this means is that the enemy is always on a reactive mode. If I can move faster than you, then you are always reacting to me and I own the initiative. And this is critical in warfare. It was critical when I went to war college back in the 1990s, and it remains true today. So the speed of cyber is being leveraged, but what that means in turn is that offensive and defensive measures that rely on human input are going to be increasingly ineffective because humans don't move that fast. And so therefore, what we're going to see is that automated and autonomous defensive systems, listen, they're inevitable. There's currently a big debate. I looked at some of the participants in the lecture today. I know you're working in this field. There's a big debate about meaningful human control of these systems. Well, I got news for you. In the future, meaningful human control will only mean two things. I understand my system's capabilities, and I understand how that system is going to act with the environment, in the environment in which I'm employing that system. That's what meaningful human control, because the notion of individuals, humans on the loop in future conflict, unthinkable because of this desire to move more quickly than the enemy. Now, cyber is going to give a lot of benefits to armies in the battle space. For example, cyber is going to make possible targeting that wasn't otherwise possible or very, very difficult. So for instance, if I want to attack my enemy's logistics systems, kinetically, I will attack the material that's being transported, and I will attack the communication system, the transportation system that's being used to transport that material, called lines of communication. But with cyber, I can attack the systems that control and determine the movement and distribution. In other words, I don't have to touch the material at all. I don't have to touch the transports at all if I can freeze them in place. If they don't know where they're going, that's just as useful as destroying them. And cyber makes that possible for the first time. But at the same time, you have to remember, cyber also makes possible conducting operations against the civilian sector that would otherwise be impossible. Imagine if you wanted to kinetically attack a tax system. I have wanted, as a British professor, to attack the tax system in the UK, Her Majesty's Revenue and Customs Service. That would be almost impossible kinetically. But I could do that. I could do that with cyber. Don't forget that NotPetya, the supply chain attack by Russia against Ukraine, started with an operation against tax software. Additionally, an operational benefit is that cyber capabilities are going to be more widely available and cheaper than kinetic weaponry. It's hard to buy a tank. It's hard to buy a warship. But with cyber, you can acquire capabilities that are really devastating on the cheap. And indeed, what this means is that small countries and organized armed groups will be able to counter kinetic superiority in the battle space. If you're fighting an enemy that is kinetically advantaged, cyber is a logical tool to turn to. You will not be able to go toe-to-toe kinetically with your enemy, but if you can get inside its systems, you can have devastating effect. And speaking of devastating, cyber can be devastating without being destructive, and that's very useful in the battlefield. Because if you prevail in battle, you will have occupation duties, and occupation duties are much easier to shoulder if you haven't destroyed everything in the space, in the area that you are occupying. So there are lots of operational benefits, but there are operational obstacles as well. Lack of transparency is a big one. Cyber has non-physical effects. You can't see and hear cyber the way you can see and hear a bomb exploding. Indeed, in cyberspace, you may not even know that you are under attack until well after the attack has concluded. Don't forget that the Stuxnet operation was meant to do exactly this. The Iranians did not know they were under attack as Stuxnet was going on. It wasn't until the operation had been underway for quite some time that they figured it out, and they only figured it out because of folks outside Iran. Sorry about that. My sister's dog just ran in here and put his head in my lap. I apologize for jumping. Cyber warfare will also demand secrecy. And this is going to depend, and this is because cyber depends on identifying vulnerabilities in the enemy's systems. So what this means is that defenders are going to work really, really, really hard to frustrate the enemy's understanding of its systems, and the attackers are going to work very, very hard to ensure that the folks they're attacking aren't alerted to the fact that they're going to be attacked, and therefore can remedy their exploitable vulnerability. And then, of course, we have the challenges we all know about: attribution, intentional spoofing, false flag operations, and so forth. The other operational obstacle that will have legal relevance is that cyber is a use it and lose it capability in many, many, many cases. So if you have a cyber capability that you want to employ in the battle space, once you employ that capability, the enemy will now know how to counter that capability. So you have to make intelligent operational decisions. Is this the time, and is this the target that I want to expend this valuable capability against? In terms of impact on civilians, what impact will cyber have on the impact on civilians? Well, cyber is going to enable, as it already has, greater precision in kinetic targeting. Why? Because you have advanced sensors and you're fusing intelligence and input, so you know more about your military objective and you know more about potential collateral damage. You can be more precise and avoid collateral damage that way. And it also offers an alternative to kinetic targeting. Just to give you an example, coming from the air environment, one of the first things that you do when you are conducting air operations is bring down the enemy's IAD system, integrated air defense system, radars and surface-to-air missiles. Well, you normally do that kinetically with special aircraft and special weapons. But today you can do that by using cyber. And to the extent you're not dropping bombs, you are conducting your operations in a way that is going to minimize risk to civilians. So there's less risk of collateral damage as a result of the advent of cyber. But in cyberspace today, everywhere in the world, whether it's the United States, Australia, or Estonia, everywhere in the world, militaries rely on dual-use cyber and cyber-enabled infrastructure, everywhere. I have an office at the War College, at the Naval War College. I mean, we store our information in the Google Cloud. You know, I'm using civilian systems on my desk. So the problem is now that they are dual use, now that there's so much reliance upon dual use cyber infrastructure, there is a greater likelihood of impact on the civilian population when you go after what are valid military objectives. There are other problems that endanger civilians. It's difficult sometimes to map the networks. If you're going after a target, you need to know what the knock on, what the bleed on, what the reverberating effects are. And sometimes in cyberspace, it's difficult to figure that out, to map the networks that your target is connected to. And then you have what I've already mentioned, attribution and spoofing problems, which run the risk of mistakenly attacking civilian infrastructure. So, quo vadis, where are we going? How will this dynamic work? Well, I believe that international law is all about, or in great part, about balancing military and humanitarian considerations. States do this. When they make law, when they interpret law, they ask themselves, what is it I require militarily? And if I'm trying to pursue humanitarian ends, if only for my own population, how can I do that without sacrificing critical military capability? And what's important in this dynamic is that a state's view of the appropriate balancing will shift over time. It will shift as the values of society shift. It will shift as opportunities both on the part of the military and the part of the civilian population emerge. It will shift as states identify risks, both military risks and risks to the civilian population. So we should expect the law to evolve as matters change. Now, sometimes cyber, the reality of cyber, is going to force evolution in this law. Normally you try to seek balance, but sometimes the nature of technology is such that, listen, the law simply has to evolve. The interpretation of the law has to evolve. And so again, and I know many people here have worked in this area, but in my view, the human in the loop, on the loop, out of the loop debate is going to go away, because the reality of speed, of cyber, and the need to operate inside the enemy's OODA loop is going to take that debate out of the realm of the practical. Most often, though, what will happen is not that cyber will force a distinct change in the way we think about IHL, but rather most often states are going to go, listen, what do I need to do and what do I want to do militarily? And then what do I want to protect? And they will do a cost-benefit analysis that will generate a shift in interpretation of the law. Now, that dynamic is going to be informed by the extent to which states see IHL as effective. So, for example, if a state believes that the other states are not going to follow IHL, then they will refrain from using IHL to limit cyber. In other words, I'm not going to tie my hands if the enemy is not going to follow the particular rule, because that will mean that law gives the enemy an asymmetrical advantage. I'm at an asymmetrical disadvantage because I follow the rules and the enemy does not. The state will also ask, is IHL effective at all? If IHL is meant to protect the values of my society, if IHL is meant to protect my country in cyberspace, but it does not, then I don't want to limit my cyber capabilities, my cyber-enabled operations, because I may need them to protect those particular values. I may need them to protect my society's activity in cyberspace. States are also probably going to seek to preserve their de facto asymmetrical cyber-enabled warfare advantages. So a country like the United States, when it looks at IHL and asks, how can we interpret this in the cyber context, is going to ask questions like, will this proposed limitation limit me more than the enemy because I enjoy cyber superiority? In other words, the enemy doesn't have cyber capability that will be limited significantly by this interpretation of the rule, but I do. And so therefore I will be at a disadvantage. And the pace of change, the pace of that evolution, the pace of that interpretive process will be determined by a state's attitude with respect to whether rules are good or bad. Do I want ambiguity in IHL or do I want certainty in IHL? If I want operational flexibility, then what I want is ambiguity. Why? Because it gives me the opportunity to craft my operations to a greater degree to meet whatever is happening in the battle space. And that's going to be beneficial for states with cyber superiority. The more powerful the state in cyberspace, the more that state is likely to like ambiguity in the law. And ambiguity will also be supported by states that are skeptical about IHL. If IHL doesn't really work, doesn't do the task that it's charged with, then what I want is ambiguity because the rules aren't going to work anyways, or not work well anyways. The flip side of that is certainty. There are states that will want to know the rules of the game. They want to know where the red lines lie. Which states are those? Those are states that are on the opposite side, the other side of what we just talked about. They're states that are broadly vulnerable to enemy cyber operations. If I'm broadly vulnerable to enemy cyber operations, either militarily or my civilian population, I want rules and I want lots of them, and I want them to be clear. Moreover, if I believe that law is effective, if I believe IHL works, then I want to leverage IHL for its protective valence. Now, I've made this seem very simple, but you must know that within states, this debate is occurring within states themselves, because within states, there are agencies, departments, ministries that are concerned with the effective prosecution of armed conflict, like the Ministry of Defense. And then there are other agencies that are concerned with protecting the nation's cyberspace, the nation's activities in cyberspace, and they will naturally clash. So in my country, for example, I would imagine that in discussions, the Department of Defense takes a slightly different view than, for example, the Department of State or Department of Homeland Security. So Schmitt's wild guess, because we're just looking into the future. My wild guess is that there's going to be a growing reliance on cyber. I think that's going to happen for sure. And growing vulnerability of cyber systems. Why? Because offense moves faster than defense in cyberspace. And what that's going to mean is increasingly protective interpretations. Big states will push back initially because they have power, but eventually what they're going to realize is that what cyber does is it takes away some of their superiority in warfare, because it is accessible to states that don't have their resources. don't have the resources of the powerful states. So what will happen is the weaker states or organized armed groups will turn to cyber in an effort to asymmetrically fight the big powers, and they will look to, for example, the civilian population to find the sweet spot that will have the greatest effect on the big power. And once big powers realize this, they'll want to use law to limit the ability of weaker states and organized armed groups to do that. There are some spoilers. Increasingly now, when I'm at the War College or at West Point, the big discussion is peer-on-peer or peer-on-near-peer conflict. Once this happens, once we think Russia-China, once the United States thinks Russia-China instead of ISIS or other groups, Al-Shabaab and so forth, once that shifts, then there's a desire to retain your cyber capabilities because you may need it in the big fact. And then the other spoiler is simply the fact that international law is in disrepute in a number of countries. It recently was in mine, and so it's difficult to push law forward when people think international law is a bad thing. Let me close up with a few thoughts on where we might be going in particular areas. Let's talk first about IACS, International Armed Conflict. So far, states seem to be unwilling to treat cyber operations as triggering an IAC, even though there have been cyber operations that would seem to qualify, such as Stuxnet, such as the attacks by Iran against the Saudi Aramco. And on and on and on, certain of the operations conducted by Russia. States just seem to feel that if we call that an international armed conflict, that's very destabilizing. But I believe that's going to shift as reliance on cyber grows, because to the extent your society is increasingly reliant on cyber, you're going to want to be able to call this an international armed conflict so that it opens up your kit bag, opens up your toolbox of capabilities to respond to the side conducting the operations against you. And a good example would be SolarWinds, the recent SolarWinds operations by Russia against the United States. I struggled to find whether those were even a violation of international law. Meanwhile, in our Congress, saber rattlers were claiming that this was an armed attack on the United States, that we were in a state of war. This was an act of war. So as we become increasingly reliant, I believe the willingness to characterize a cyber operation as triggering an international armed conflict will grow. The problem's going to be, well, okay, but what is it that will be determined to be the threshold? Where will the threshold lie? How do we articulate the threshold? Will we talk about severity? Will we say, oh, if you engage our critical cyber infrastructure, that's enough? I'm not sure where we'll go. The other important point with regard to IACS is that the very pervasive use of proxies in cyberspace. It's almost more common to use proxies than it is to use organs of the state to conduct these operations. And the challenges of attribution are going to lead to a relaxation of overall control standard, the overall control standard for internationalization of a conflict. If everyone's going to be using proxies to engage in these operations, it seems to me that states are going to be more willing to characterize that use of proxies as overall control. And so that threshold is likely to drop. What about non-international armed conflict? Well, today, of course, there are two requirements: intensity and organization, Tadic. With regard to intensity, applying the standards that are in place today, we probably haven't seen cyber operations by non-state actors that are high enough to reach that threshold. But I think what we need to remember is we've only seen the tip of the iceberg with regard to the severity of cyber operations. And the greater the reliance of societies on cyber, the more likely, just like international armed conflict, that threshold's going to drop. I can foresee a time when even non-destructive operations by non-state actors will be considered to have initiated a NIAC, at least reached the intensity threshold. so long as the disruption across society is very, very, very severe. An example would be cyber attacks against critical infrastructure that would not otherwise qualify for a NIAC. And then the same with regard to virtual organization. I've written about the fact that virtual organization seems to preclude having an entirely online NIAC, but I think that will change. The problem was that organization usually meant you had to have a way to enforce discipline, but I think that will go away, and it was difficult to do, but I think that will go away, and I think the new standard will be, are these entities that may not even know each other, are they operating collaboratively? If they are operating collaboratively to conduct operations at the requisite level of intensity, I believe that that's likely to satisfy the organization criterion. Geography of war, again, I've written a little bit about this. With respect to neutrality, the understanding of neutrality's obligations will narrow. There are lots of discussions about whether or not belligerents can conduct cyber operations through the infrastructure of a neutral state. If an attack is conducted, is that the transportation of weapons across neutral territory, which of course is forbidden? I think we're going to get to the point, just because of the way the technology works, where you can't really necessarily control where your operation is going to pass through. I think we're going to get to the point where the restriction on conducting operations from belligerent territory will be limited to operations actually conducted from belligerent territory or conducted using cyber infrastructure. In terms of NIACs, I think it's likely that the law of armed conflict, the international humanitarian law, will apply everywhere, because operators in a NIAC will operate from everywhere. So the notion of spillover conflict or conflict being limited to the state where the operations are occurring will fade away. We'll still have the problem of, how do I conduct operations into another state, the problem of sovereignty, but IHL will apply to that operation. Attacks, the premise that attacks, the definition of attacks should be limited to physical damage, cyber operations that cause physical damage or injury, physical injury, that's going to go away. Why? Because societies are too vulnerable to keep potential civilian targets on the table by saying they are not attacks. And moreover, most of those attacks yield little military benefit. Everyone's going to accept the loss of functionality standard that we invented in the first Holland Manual group. And I believe eventually most states will come around to the French approach, which says that even if effects are temporary or reversible, if you have to repair the equipment, replace a part, reinstall the network, something on a network, the operating system, that will qualify as an attack. I think most states will come away to the French view. And so therefore, if you conduct an operation having these effects against civilian infrastructure, you will have violated IHL and committed a war crime. Cyber will do away with the war-sustaining argument of the Americans eventually. Why? Because even in this country, that would open the door way too wide to operations. It would open the door to cyber attacks against the American banking system, against the IRS, the American tax system, key sectors of our economy. To take the war-sustaining approach to the definition of military objectives and transpose it into a cyber-enabled conflict environment would be to create an exception that would swallow the rule. On the other hand, because of the pervasive use of civilian cyber infrastructure, I believe that the old notion that I have written about many times and that we used, for example, in the Harvard Manual, that any use of civilian systems, civilian objects for military purposes, no matter how slight, rendered the object a military objective, I think there will be pushback on that, and there will be a return to the Article 52 definition of a military objective, focusing on whether the contribution to military action is truly effective and whether neutralization offers a definite military advantage. So strict application of Article 52. Proportionality is limited when you're considering collateral damage. That's only incidental damage to civilian objects. What do we mean by damage? That definition will track the definition I've just talked about in terms of attacks. Certainty will be a big problem. I talked about the lack of transparency, spoofing, attribution, and that's going to be problematic for warfighters, for operators on the battlefield, because on the one hand, you need speed, and on the other hand, there's a higher risk of misattribution. There's a higher risk that the operator conducting the cyber operation doesn't understand the knock-on effects of his or her operation. And so therefore, because of that dynamic, we're going to discard formulaic standards like reasonable certainty or whatever the countries are using at the time, and it's going to be a contextual determination. I've written about that in the Harvard National Security Journal with Lieutenant Colonel Mike Schaus. You can see our views there. With regard to attacks, I can't stand the discussion on data anymore. So I will concede that the most sensible approach has been by my friend Heather Harrison-Dinnis of the Swedish Defense Academy, and the approach taken by France that distinguishes between content and operational level data. That's the best practical approach. The problem is it's difficult to fashion a legal justification for that approach. And so therefore, I've written an article called Wired Warfare 3.0 that says, listen, we're not going to fix that problem, and we're not going to fix the problem of attacks probably. So when you're conducting your operations, you should adopt policy approaches that protect essential civilian functions or services. And if you conclude IHL is not applicable to a cyber operation, you should nevertheless apply a form of proportionality analysis, not exactly proportionality, but a form of proportionality analysis to determine whether your operation is justified or not. And finally, precautions in attack, which I believe to be the most important IHL rule in the conduct of hostilities. We've always looked past the Article 57(1) obligation to take constant care. We wondered what it is. Is it a rule? Does it apply only to attacks or to all military operations? I believe constant care is going to loom large. That operators will have to really, it will be a hard rule, a primary rule. They will have to have taken deep care to ensure that they are not affecting civilian systems, even if the harm caused civilian systems does not qualify as damage in the proportionality analysis. Verification, there will be more verification, but because of the need of speed and the lack of capability on the part of some states, there's going to be, again, this. Verification will become easier and verification will become harder. And lastly, with regards to methods and means, we all shout the praises of cyber because it's an alternative to kinetic operations, but don't forget the word feasibility. You only have to use a method or means if it's feasible in the circumstances, and states are going to say in many cases their option, their alternative to kinetic operations is not feasible because they're unwilling to lose it at that time. And with that, I'll stop here and turn it back to Russell.
Thank you very much, Professor Schmitt, for that very rich, informative and engaging presentation. So we have questions coming through thick and fast on the chat function. I think you can see those, Mike, but let me, I've had the opportunity to summarize them. So let's take two at a time. The first is from Paige and relates to whether their new law is needed in the context of armed conflict and whether the existing instruments we have are inadequate. And the second question comes from Fanika, and her question is whether or not the cyber capabilities of smaller states have increased their military capacity in the context of armed conflict, and whether or not there are any trends discernible in this context.
Okay, with regard to new law needed, so this has been the big debate. My answer is Absolutely not, except at the margins. Why? Because international law allows for interpretation of existing norms. And as we found out in the Tallinn manual effort, when we started looking at IHL and applying it in the cyber context, so long as you are interpreting in good faith, you could come to some pretty reasonable conclusions. Moreover, listen, it's hard to get new law, whether it's customary or treaty. So most of the action will be an interpretation. I don't think new law is necessary. There are a few areas. I'm really nervous about this data debate, because I think we can all agree we want to protect some civilian data, but on the other hand, we don't want to put an absolute prohibition on going after civilian data. And there, I'm hoping that the policy positions that I've suggested in Wired Warfare 3.0 eventually mature into hard law. With regard to the capability of smaller states will increasingly, and by the way, non-state actors, organized armed groups will increasingly turn to cyber because they can't compete with more powerful states in terms of kinetic weaponry, but they can compete with those states in terms of cyber capabilities. So we're going to see them acquire cyber capabilities, easier, cheaper.
Okay, thank you. Thank you for that, Mike. The next question comes from Jan, and Jan is asking about the law of neutrality, and in particular, when attacks are routed through third states against the victim state, and as to whether there are any IHL limitations regarding counterstrikes within the cyberspace of those third countries once an armed conflict is underway. And then we have a question from Larissa, which is about what deterrence looks like in cyberspace during times of armed conflict, and whether you can comment on that.
All right, with regard to the law of neutrality, this is a big debate. The debate is about whether or not you may route attacks through neutral territory. My particular view is yes, you can. And the reason is, first of all, I've taken the position that cyber capabilities are not means of warfare. They are merely communications, and communications through neutral territory are allowed. Moreover, there's the very practical aspect of how do you conduct an attack during an international armed conflict and not have your operation routed through neutral territory, even if it's unintentional. It may unintentionally occur that way. So the question then becomes counterstrikes. I do not think that counterstrikes are permissible into neutral territory to put an end to operations that are routed, that are intentionally or otherwise routed through neutral territory, in the same way that historically you couldn't conduct counterstrikes to preclude communications from being routed through neutral territory. However, if cyber infrastructure is being used, in other words, someone is taking control of cyber infrastructure on the neutral territory, then the neutral state has an obligation under the law of neutrality to put an end to that misuse of its territory. And if it fails to, it's my view, and the majority of the Tallinn Manual group, that then the aggrieved belligerent can take operations, limited operations, to stop the use of that cyber infrastructure on the territory. So we have to distinguish for the operations conducted through territory and the operation where you intentionally take control of cyber infrastructure and then use that cyber infrastructure as an integral part of your operation. Deterrence, that's really an oddbellum question, and it's one that folks are talking about. The problem with deterrence is that deterrence is generally conceived of as effective when the other side has the capability to punish you, and you know they have the capability. And the problem is in cyberspace, the capabilities are so secret that you really don't know whether the other side has the capability to conduct operations against you that deter you from engaging in your own hostile operations. So that's the problem with deterrence, but that's really not an IHL. An IHL, deterrence doesn't work very well because you're at war.
Yeah, thanks, Mike. That's a really interesting response to the neutrality question. One of my questions to you would have been, in what area of international humanitarian law do do you think cyberspace has impacted most significantly since you started working on this topic? Or perhaps even what's the biggest change from, say, Tallinn Manual 1 on the law of armed conflict to Tallinn Manual 2? Where did you see most changes? I mean, for me, I think the law of neutrality, I think the ICRC referred to it as a musty doctrine, but I think in the context of cyberspace, neutrality has been given a new lease of life, and there are lots of interesting, important questions there.
Yeah, I think you're right. Neutrality was a bit of a change from 1 to 2, and I think it'll change dramatically now. The other area where I think it will change is the understanding of cyber as a means of warfare. We said it was a means of warfare in Tallinn 1. We kept that in Tallinn 2. I don't know if that's what's going to come out in Tallinn 3. I think there will be an option that says it's not. I recently changed my mind on this. I wrote about it in International Law Studies. I was working with an Air Force colonel who was legal advisor to one of the Air Force cyber units. And he said, Mike, if I take you to the top of this building and I tell you jump, 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 that's not a means of warfare. I'm just convincing you. And all that's happening with regard to cyber is one computer is trying to convince another computer to do something. It is the other computer doing something that causes the effect. And so, I mean, it's much more complicated than that, obviously, but I think that's the other area. The way we consider cyber capabilities. In fact, here in my country, we really don't talk about cyber weapons anymore. We talk about cyber capabilities. It's viewed more as a method of warfare than a means of warfare, but absolutely in neutrality, absolutely.
Okay, I think we have time for one last question. I know someone's been waiting quite patiently. So the question is, what does the development of virtual organizations based upon collaboration mean for command responsibility?
Oh, that's yeah, briefly. Okay, that should be easy. So the whole premise of command responsibility is that I have control over someone that's operating. In other words, I can keep that individual from doing something, or I can punish that individual if I discover that that individual has done something that is violating international law, that commits a war crime. And in virtual organization, that may be possible, but the big problem there is going to be, how do I discipline someone? Now, when I talk to the techies, the wireheads, the experts, what they all say is, well, we'll kick that person out of the group. Now, I think of that as, come on, that's not discipline. But on the other hand, in the armed forces, when we have someone who doesn't abide by the rules, one of our options is discharge that individual from the armed forces. So I'm skeptical about that qualifying as discipline, but I need to think more about that. But the ability to control the person while they're engaging in the operation, I think that's going to be tough. Command responsibility will be difficult unless you lower the threshold. And that's one of the things we're talking about today. Maybe if you organize a group and you are actually the leader of the group and you are failing to tell your folks to not do this, which would violate IHL, and not do that, maybe that's going to be enough. But to be frank, it's a wonderful question. I haven't thought much about it. And if someone wants to write a great article on the subject, I'll publish it in International Law Studies or the Journal of International Humanitarian Law Studies, which would be even better.
Thanks for the promotion, Mike. Yeah, I mean, I guess, command responsibility, you can't lower the threshold too low, right? Otherwise it becomes like the doctrine of joint criminal enterprise, where you just convict everybody. So there has to be a link. So I don't think command responsibility can be the panacea to all these problems. Okay, so we've reached the end of the allotted hour. It only falls upon me, unless Ryan and Emily want to chip in with anything, to thank again our good colleague, our good friend and loyal supporter of the journal, Professor Mike Schmitt. And if we were in a physical room, everyone would join me in rapturous applause. But in the absence of that, I hope my thanks are enough. Thank you to everybody for attending. Thank you for your engaging questions. And please do feel free to send submissions to the Journal of International Humanitarian Legal Studies. Thank you very much, everybody. Thank you. Thanks,
Thank you.
Mike.
Thank you very much. Thanks.